Welcome to the 37th video in our weekly legal update series. In this video, we will be discussing important news events from 2nd August to 7th August 2021. In first important news, the Supreme Court has said that mere possible apprehension of breach of law and order cannot be a ground under preventive detention laws. In the case of Vaka Sneha Sheila versus State of Telangana, the Supreme Court has said that a possibility of apprehension of breach of law and order cannot be a ground to detain a person under preventive detention laws. Further, the Supreme Court said that a preventive detention order can only be passed if the activities adversely affect or are likely to adversely affect the maintenance of public order. In second important news, the Supreme Court has said that burden to prove defense under section 313 CrPC on the accused is not beyond all reasonable doubt. In the case of Pramila versus State of Uttar Pradesh, the Supreme Court has clarified that the burden of proof on an accused to prove his defense taken under section 313 CrPC is not beyond all reasonable doubt, as it lies on the prosecution to prove the charge. In third important news, the Supreme Court has said that a second appeal cannot be disposed of in a summary manner after its admission with formulation of substantial question of law. In the case of Ramdas versus Gyanchand Kripalani, the Supreme Court has said that once a second appeal is admitted and substantial question of law formulated, the matter cannot be disposed of in a summary manner. The appeal is required to be heard in terms of Order 42 of CPC. In fourth important news, the Supreme Court has said that a governor can exercise his power of pardon even if the prisoner hasn't undergone 14 years of imprisonment. In the case of State of Haryana versus Rajkumar, the court has clarified that a governor's power under Article 161 of the Constitution to commute sentence or pardon overrides the restrictions imposed under Section 433A of CrPC. The court has said that even if the prisoner has not undergone 14 years or more of actual imprisonment, the governor still has a power to grant pardon, reprieve, respite, and remission of punishment, or to suspend, remit, or commute the sentence of any person. In fifth important news, the Supreme Court has said that witnesses cannot be tried for perjury under Section 193 of IPC for mere inconsistency in their statements. In the case of Nandisha Reddy versus Kavita Mahesh, the court has said that prosecution for perjury cannot be ordered if there is no intentional falsehood. The court has also said that mere reference to inconsistent statements alone is not sufficient to take action unless a definite finding is given that they are irreconcilable, one is opposed to the other, so as to make one of them deliberately false. Lastly, the Supreme Court has said that previous sanction of central government is not required at the stage of taking cognizance for offences committed outside India. In the case of Nerala Chiranjeevi versus State of Andhra Pradesh, the Supreme Court has said that previous sanction is not required at the stage of taking cognizance. However, the trial of the criminal case against an Indian citizen for offences committed outside India cannot begin without the previous sanction of the central government under Section 188 of CrPC. This brings us to the end of our news. If you like the content, please like, share and subscribe to our channel.